Imagine this. You're renting a place, the stove breaks down, and your landlord tells you straight up, "I can't afford to fix it." So you go out, spend your money, buy a brand new stove and microwave, leave it behind when you move out, and then have the nerve to ask for your money back. But here's the twist. The landlord already paid half. So who's actually in the right here? Stick around, because Judge Judy is about to slice through the drama like only she can. This case takes place in a small claims courtroom, and the tension in the air is thick enough to cut with a knife. Mr. and Mrs. Lujan are standing before the legendary Judge Judy Scheindlin, and they are fired up. They rented a condominium from a woman named Carol starting back in February of 2011. Their monthly rent? A solid $1,995. They stayed for over 3 years, all the way until July 1st, 2014. That's not just a short-term rental situation. These people made that condo their home. They watered the plants, they knew the neighbors, and they treated that place like it was their own. But when they finally packed their bags and walked out that door, they left something behind, something expensive, and now they want to be compensated for it. Now, Judge Judy starts the case by mentioning a washer and dryer. But Mrs. Lujan immediately corrects her, loud and clear. It wasn't the washer and dryer. It was the stove and the microwave. Specifically, the stove and the built-in microwave above it that came with the condo. Just 4 months after moving in, around June of 2011, these appliances started failing. The oven couldn't maintain a proper temperature. The knobs were broken. You couldn't cook a proper meal even if you tried. And let's be real, when you're paying nearly $2,000 a month in rent, you expect a functioning kitchen. That's not asking for luxury. That's asking for the bare minimum. So Mrs. Lujan picks up the phone and calls Carol, the landlord. She explains the situation. The stove isn't working, the oven temperature is off, the knobs are broken, the microwave above the stove is dead. A reasonable landlord would have said, "I'll get it fixed by next week." But Carol had a different answer. She told Mrs. Lujan that she was unemployed at the time and simply could not afford to replace the appliances. Now, that's a tough spot to be in, no doubt. Nobody wants to be unemployed. But being unemployed does not erase your legal responsibility as a landlord to provide a livable, functioning space to your tenants. That's Landlord-Tenant Law 101. You cannot collect rent and then tell someone to cook their dinner on a broken stove. To her credit, Carol didn't completely ignore the problem. She did something. She loaned the Lujans a separate, working countertop microwave to use in the kitchen. So now they had 2 microwaves in the kitchen. One sitting on the counter that actually worked, and one built into the wall above the stove that was completely useless. It was a temporary band-aid on a bigger wound, but at least it was something. Judge Judy acknowledges this. The Lujans had a working microwave, borrowed from the landlord, sitting on their counter. So the microwave situation for the moment was patched up. Then tax season rolls around. Mr. and Mrs. Lujan get their income tax return back, a little extra cash in their pocket. And they make a decision. Rather than continue living with a broken stove and a wall microwave that doesn't work, they're going to buy new ones. Now here's where it gets interesting. They don't just go ahead and do it alone. They actually sit down with Carol and have a conversation about it. Carol agrees to look together on Craigslist and at local stores to find the best possible price. The agreement, as Mrs. Lujan describes it, was this. The Lujans would find the best deal, purchase the appliances, and Carol would reimburse them, either right away or once she got back on her feet and found employment. And because she wasn't paying up front, the Lujans deducted half the cost from their monthly rent. So technically, Carol paid her half through a rent deduction. That part is done. But the other half, the Lujans' half, that was never reimbursed. And this is where Judge Judy does what she does best. She listens carefully, cuts through all the extra noise, and gets to the core of the issue. She points out something the Lujans did not mention in their original complaint, that Carol had already paid half. When Mrs. Lujan finally admits this on the stand, Judge Judy doesn't let it slide. She makes it crystal clear. Carol's half payment was essentially equivalent to what it would have cost her to simply buy a used stove and replace the broken one. Think about it, a used stove might cost, say, $400. A brand new stove might cost $800. Carol's logic was, if they want a new one, I'll chip in what I would have spent on a used one. That's actually reasonable. She wasn't trying to get away with anything. She drew a line. I'll pay what a basic replacement would cost me, but if you want the fancy new model, that upgrade is on you. But Mrs. Lujan isn't done. She brings up email correspondence between her and Carol. Apparently, while they were both browsing Craigslist for a used stove, Mrs. Lujan found one she liked at Sears, a brand new model. She emailed Carol about it, and Carol's response was essentially, "Buy whatever you want. You're the one who's going to be using it." Now, Mrs. Lujan is presenting this as proof that Carol gave her permission to buy a new stove and agreed to pay for it. But Judge Judy shuts that argument down immediately. That email doesn't prove Carol agreed to pay the full cost. It proves Carol gave them the freedom to choose, which is different. And the reason they bought new instead of used? They couldn't find a used stove seller who would deliver because they didn't have a truck. Judge Judy's response to that? Classic Judy. I don't care. That's a whole big story that it's not necessary for me to care about. Now, stepping back from the courtroom drama for a second, there's a very real and important issue buried inside this case. Tenants across the country face this exact situation every single day. A landlord provides an apartment or house with appliances included. Those appliances break down. The landlord claims they can't afford the repair. And the tenant, who is already paying rent, is suddenly forced to choose between living without a functioning kitchen or spending their own money to fix someone else's property. That is not okay. In most states, landlords are legally required to maintain what is known as the implied warranty of habitability. This means the rental property must remain livable, safe, and functional throughout the duration of the lease. A broken stove, especially one that was included in the original rental agreement, falls squarely under this responsibility. The landlord cannot simply throw their hands up and say, "I'm broke. Figure it out yourself." Legal experts will tell you that the Lujans had options they may not have fully explored before reaching for their wallets. First, they could have sent Carol a formal written notice documenting the broken appliances and giving her a specific deadline, typically 30 days, to make the repairs. Second, depending on the laws in their state, they may have had the right to repair and deduct, meaning they could fix the appliance themselves and legally deduct the full cost from rent, not just half. Third, if Carol had refused to respond, they could have filed a complaint with the local housing authority or code enforcement, forcing the issue through official channels. Instead, they made an informal agreement, paid out of pocket, and left the property without fully protecting their legal interests. That's how good people end up in courtrooms. And then there's the microwave they bought, the new over-the-range microwave that fit perfectly into the space where the old broken one had been. When the Lujans moved out, they left it behind. They're asking Carol to pay them for it now. Judge Judy's take on this is straightforward. The Lujans bought an appliance, installed it in a rental property, and left it there. Legally speaking, once you permanently attach something to a rental property, especially something that fits a built-in space, it typically becomes part of the property. You can't come back 3 years later and say, "Pay me for the microwave I installed." You should have taken it with you when you left, or negotiated its value before signing off on the property at the end of the day. This case is a lesson for both landlords and tenants. For landlords, your financial problems are not your tenant's problem. If an appliance breaks, fix it. That's your job. If you can't afford the full repair right away, communicate clearly, put agreements in writing, and follow through. Shaking hands and sending casual emails is not a contract. For tenants, document everything. The moment something breaks, send a written notice, email, text, certified letter, something with a timestamp. Never spend your own money on a landlord's property without a clear, written agreement about reimbursement. And if you're leaving appliances behind when you move out, get that value accounted for in your final walkthrough. Protect yourself, because the courtroom is a frustrating, expensive, and emotionally draining place to sort out something that could have been handled with a simple paper trail. Judge Judy may have been sharp, even a little cutting in her questioning, but she wasn't wrong. The Lujans had a legitimate grievance, but they handled it loosely. Carol had a responsibility she tried to dodge by hiding behind her unemployment. The truth, as always, lives somewhere in the middle. And that's exactly where Judge Judy lives. right in the middle of the mess, separating nonsense from legitimate claims, one case at a time. If you found this breakdown useful, smash that like button, drop your thoughts in the comments below, and don't forget to subscribe so you never miss another case breakdown. New videos every week.